Welcome to Indian Patent Agent Examination Preparation video series by Pathways Consulting Solutions, session 5. Today's session we are going to discuss about the Indian Patent Act, chapter 3. Applications for patent. Person entitled to apply for patent, or simply who can apply for a patent. According to this section, there are three persons who can apply for a patent. One is a true and first inventor, which means the inventor himself. Or two, the assignee of the true and first inventor. If the inventor assigns his right or transfers his right to another individual or to another company or organization or university, then the individual, university or organization can also apply for the patent. Third is a legal representative of any deceased inventor or a deceased assignee. So before his death, if he has assigned his rights to his legal representative, then the legal representative can also apply for patent. According to subsection 2, all of the above three persons individually or together, which means the inventor alone can apply for the patent, or the inventor along with the assignee can also apply for the patent. Section 7 talks about the form of application. How would one want to apply for the patent? Now this section prescribes that every application for a patent shall be for one invention only. This is a very important criteria. So each invention should be filed a separate patent application and it shall be filed in the patent office. Now 1A. Every international application shall be filed under the PCT, which is the Patent Cooperation Treaty, designating India as the receiving office. Now 1B. The filing date of an application referred in the designated office or elected office shall be the international filing date accorded under the PCT application. Subsection 2 says, where the application is made by virtue of an assignment of right to apply, which means if the assignee is the one who is applying, then the proof of right, that is the proof that the assignment was made by the inventor to the person who is applying, should also be filed along with the application. Every application for patent shall contain a declaration by the applicant claiming that he is in possession of the invention and claiming that the person to be the first and true inventor is actually the person true inventor. Further, every such application, except being a convention or a PCT application, should be accompanied by a provisional or a complete specification. Section 8. Information and undertaking regarding foreign application, which is saw in Section 7 the form of application. According to Section 7, we have to file a proof of right, which is in Form 1, definitely a declaration of inventorship, which is in Form 5, and then a complete or a provisional specification in Form 2. Now further to all of these three forms, there is another important form that an application should be accompanied with, which is called as the information and undertaking regarding any foreign application. There are two important details that has to be furnished along with this. One, a statement setting out all the details of the foreign application, which means if the applicant has filed any foreign application, the application number, the title of the invention, the country in which it was filed, the date in which it was filed in each of the countries has to be detailed. Further, the applicant or the inventor also should give an undertaking to the Controller of India that the applicant will keep the controller informed about the status of each of these foreign applications from time to time until the grant of the Indian patent. Further, subsection 2 also says the controller also has the power to request the applicant to furnish any such details while the application has been filed in India until the time it has been granted or rejected. He can also ask for these details of any application that is filed in any of the foreign countries. Section 9. Provisional and complete specification. So this section deals about the Form 2, that is along with the applications you will also have to file either a provisional specification or a complete specification. So according to subsection 1, where an application for patent is accompanied by a provisional specification, then a complete specification shall be filed within 12 months from the date of filing of the provisional specification. If the complete specification is not filed within 12 months, then the entire application for patent shall be deemed to be abandoned. according to subsection 2, where two or more applications of the same applicant are accompanied by a provisional specification and the controller is of the opinion that these two inventions constitute a single invention, then according to section 9(2), there can be one single complete specification that can be filed in respective of the two provisional specification. However, the date of time of the 12 months shall be the first of the provisional specification. For example, if one specification provisional has been filed on the 1st January of 2021 and another provisional specification has been filed on the 1st February of 2021 and it is being decided that these two provisional specifications together can be one single application, then the filing date of the complete specification shall be 1st January of 2022, which is the earliest date of the two provisional specifications. According to subsection 3 of section 9, where an applicant has directly filed a complete specification and then he realizes that he needs more time, then he can request to the controller to convert the complete specification into a provisional specification so that he gets another 12 months time to file a complete specification. Now subsection 4 says where a complete specification has been filed after a provisional specification, then at the request to the controller, the applicant will also cancel the provisional specification and convert the complete specification to the provisional specification. In that time, this application gets post-dated. That is, the filing date of the application becomes the filing date of the complete specification, and from then another 12 months time is given to the applicant to file the new complete specification. Contents of a specification. Section 10 details about what are the contents that a specification, be it a complete specification or a provisional specification, should contain. Subsection 1 says that every specification shall describe the invention and shall begin with the title sufficiently indicating the subject matter of the invention. Subsection 2 details that a provisional specification or a complete specification shall be supported with drawings and these drawings shall be a part of the specification. Subsection 3 says if the controller requires an illustration, model or a sample, then the applicant shall provide the illustration or the model before the application gets granted. However, this illustration, sample or model shall not be deemed to be a part of the specification. These shall only be provided to the controller in order to understand the invention for the grant of the invention, and hence these need not be a part of the specification. Further, subsection 4 of section 10 details about the very particulars of the complete specification. It is one of the important criteria of a complete specification. A. It should fully and particularly describe the invention, its best method, its operation in which the invention is supposed to be performed. B. It should disclose the best method of performing the invention which is known to the applicant and for which he is claiming the protection. C. The description or the specification should end with claim or set of claims clearly defining the scope of the invention. D. It should be accompanied by an abstract to provide the technical information on the invention. Now further, the controller may amend the abstract for providing better information to the third parties. This is done because during the publication of the invention, it is the abstract that gets published for the public to read. Hence, the controller at his discretion may require the applicant to amend the abstract of the specification. Further, the complete specification should also contain material evidence or details pertaining to biological materials that has been used in the invention. Further, relating to the biological material, depositing of the biological material to an international depository or a repository that is recognized to be an international repository is mandatory. Under this deposit should be made before the filing of the provisional or complete specification. So, in the process of filing of a specification, first any biological material has to be deposited under the international depository and the details of that deposit should be in the part of a provisional or complete specification. 2. The name, the address of the depository institute, the date and number of the deposit should be in the complete or provisional specification. Then Access to the material should be available only after the date of application of patent in India, or if a priority is claimed after the date of priority. D. The source and geographical origin of any biological material that is used in the invention should also be mentioned in the specification. Furthermore, if the application is an international application, which means it is filed under the PCT, then only a complete specification shall be filed. That international application shall have a title, description, drawings, abstract and claims. Now, the claims or claim of a complete specification shall relate to a single invention only. Further, a declaration as to the inventorship, which we've already seen in the previous section, wherein the applicant should claim that he is in possession of the invention, and the applicant should indicate that the person claiming to be the inventor is the true and first inventor. That is, the declaration of the inventorship should be attached. Further, subject to the foregoing provisions of this section, a complete specification, if it is filed after a provisional specification, then such complete specification should have a claims. Section 11 talks about the priority dates of claims of a complete specification. The priority date is a very important concept, as this date indicates the date on which the invention is first disclosed in a patent application. There shall be a priority date for each claim of a complete specification. Now, where a complete specification is filed in pursuance of a provisional specification, and the priority date of the provisional specification shall be the priority date of the application. Further, if by virtue of subsection 3 of section 9, wherein you are filing a provisional specification or a complete specification, you are abandoning the provisional specification or you are converting the complete into a provisional specification, then the priority date of that particular application or every claim of the application shall be the date of filing of the relevant specification. Now, subsection 3 talks about wherein an application is filed and the application is based upon two or more applications. It is two or more provisional specification combined to form one single complete specification. In such case, part A, that is the priority date of the complete specification, shall be the priority date of the application, that is the provisional specification for which the complete specification has been filed. So if A and B are two provisional specification and the complete specification has been filed only for A provisional specification, then that shall be the priority date. Now further, if both A and B provisional specification disclose the part of the invention, that is part of the complete specification is from A and part of the complete specification is from B, then the later date, so of the both, the later date of the provisional specification shall be the priority date of the complete specification. Now, according to subsection 3A, where a complete specification has been filed in pursuance to a provisional specification, that is within the 12 months time, then the complete specification's priority date shall be the provisional specification in which the matter was first disclosed. Further, in cases of two or more priority dates, the priority date of each claim shall be the earlier or earliest of those two dates, which means if there are two priority dates, the earliest of the priority date shall be the priority date of the claim of the complete specification. Now, in a scenario where none of the previous sections or scenarios apply, then the date of filing of the complete specification shall be the date of priority. Now, subsection 8 talks about what is the importance of determining the priority date. So, we have now seen multiple scenarios in which the priority date of an application, whether it is filed after a complete specification or it is filed directly as a complete specification or it is filed as a PCT application, or in cases where two provisionals are fused to form one complete specification. So, the different scenarios have been analyzed in this section. Now, subsection 8 talks about the importance of what a priority date is. Now, just because a priority date has been identified, this subsection says a claim in a complete specification shall not be invalid only reason of two scenarios. One, if there has been a publication or if the invention is used in the market after the priority date, Or 2, there has been another patent that is granted which also claims the same invention on later of the priority date. Hence, this subsection talks about the importance of priority date. The use of an invention or publication of an invention or a grant of another patent, all of which relating to the same or substantially same claims after the priority date shall not affect the application of this particular patent. With this, we come to the end of the session that talks about forms of application, the importance of priority dates, the different types of applications, complete and provisional application, and the contents of application. Now, stay tuned for further sessions in this video series. Please leave your queries and comments in the comment section. Thank you.